Hello everyone and welcome. My name is Ian Quayle from IQ Legal Training, and for the next hour or so I'm going to share with you some of my thoughts with regard to residential conveyancing. The heading is entitled "The Terrible Truth About Residential Conveyancing." There are some terrible truths in connection with the conveyancing process, unfortunately. A little bit about me. Sadly, I qualified as a lawyer many years ago, and for the last nearly 18 years I've spent my time training lawyers, both in the context of commercial property work and also residential conveyancing. I also do work for a number of different organisations, everything from professional indemnity insurers to search providers, etc. So I feel that I've got a fairly considerable view as to what conveyancers do well and what they do not so well. What I want to do is to share my views and my thoughts, and to give estate agents a sort of an insight into some of the problems associated with residential conveyancing currently, in the hope that the professions, as it were, can continue to work together to ensure that conveyancing transactions are processed swiftly and efficiently to the satisfaction of clients. So hopefully you're sitting comfortably. This event is being recorded. There are slides that accompany today's presentation, but there aren't any notes. If anyone has any questions or queries about anything I say, or they'd like clarification about any points that I raise, do feel free to drop me a note via email, and I'll endeavour to assist and provide some form of meaningful response. My response times aren't particularly impressive at the moment, due to the amount of work that I've got. But if you do send me an email, I will respond and acknowledge, and will get back to you as swiftly as I possibly can. So first of all, as I do when I'm doing any training with any conveyancers or any property lawyers generally, there are some useful websites. HM Land Registry contain useful information about land registration news. They also contain practice guides. Practice guides are the Bible for residential conveyancers dealing with registered land. Those practice guides are altered and updated on a fairly frequent basis, and they highlight good conveyancing practice and also highlight what the land registry expect from conveyancers. A failure to comply with a practice guide can generate problems for everyone concerned. So it's important that property professionals generally, conveyancers in particular, are familiar with practice guides to seek advice and guidance in that connection. So we've got Practice Guide 40, for example, that deals with plans and boundary issues. We've got Practice Guide 19 that deals with issues in the charges register. Not just mortgages are contained in the charges register, but other interests in land. So it's important that practitioners are aware of how the land registry deal with notices or restrictions on registered titles. So practitioners will use it as an estate agent. The land registry practice guides are technical really for the conveyancing process, but might be of use to you if a conveyancer is telling you about a problem or an issue. Then you can look at an appropriate land registry practice guide that might generate an answer for you or provide some useful background. For example, there might be a problem in connection with an adverse possession claim. There's a land registry practice guide that explains how an application can be made to the land registry for adverse possession to claim a possessory title on the basis of 10 years occupation if the land is registered, 12 if it's unregistered. So that's the first site that I mentioned, and it contains numerous practice guides and news about what the land registry is up to. One of the big bones of contention for conveyancers currently is the amount of time the land registry is taking in connection with applications for first registration. I thought that the worst I'd seen was up to 2 years for an unregistered title after completion to be registered at the land registry, until Thursday last week, where someone told me that they'd been waiting 3 years for an application for first registration to be processed. Unregistered land, there's approximately 1.4 million properties in England and Wales that haven't been registered at the land registry. If you purchase land that is unregistered, or property that's unregistered, or you mortgage land that is unregistered, then the position is that you are obliged, as part of the conveyancing process, to register the unregistered title. And unfortunately, where that process is taking 2 years, and as I say, recently the worst case scenario 3 years, you can imagine that it would be difficult, if not impossible, for the owner of that land to sell it again. So frequently there's a sort of blockage in the conveyancing process, until a parcel or a property that's unregistered land is registered, and then it's capable of being dealt with as registered land. To be honest with you, registered land is a lot easier to deal with in most cases, on the basis that there's standardized forms, there's proof of ownership, courtesy of the register, the official register. So it's probably worthwhile, if it's possible, to register unregistered land, so it makes it easier to deal with long term. You can, of course, apply to voluntarily register unregistered land. In other words, you can ask the land registry to register unregistered land, even though you're not selling it or buying it, and even though you're not mortgaging it. Anyway, the next site that I mentioned is property protocols. One of the big problems for conveyancers, and a problem for surveyors and estate agents too, is the issue of what's the extent of the land that's being sold or bought in the conveyancing process. Is it an area that's contained within a fence? Is it a property contained within a walled garden? Is it a new plot, in which case it's been staked out by white stakes, etc.? How do we identify the physical extent of some land or a property that's being bought or sold? What you've got to realize is that the actual boundary itself is in essence smaller than a pencil line that separates my land from your land. But the moment we put that pencil line onto a plan, be it a title plan, an ordnance survey plan, a plan used for the division of land in any context, a red line or a white line can be, in fact, when scaled up, a metre or a metre and a half wide. And if we have a client that needs to know exactly where the western boundary sits, it's of little use to them to think, well, it's somewhere in that 1.5 metre strip of land. You know, if you're going to build as close as you can to a western boundary, if you're worried about a ransom strip or something of that nature, you need to know exactly where your legal boundaries are, and you need to know the physical extent of the land that you are acquiring. Property Protocols is a website that's free to access. It contains a protocol, a framework for dealing with boundary problems. It sets out the problems that land lawyers and property lawyers have in connection with boundary identification. It sets out the sorts of boundary disputes you can encounter and the sorts of things you can do in order to identify a legal boundary, be it a determined boundary application being made to the land registry, or be it a formal boundary agreement between property owners that recognises and acknowledges the boundary between them. The RICS has a consumer guide to survey and valuation. It has lots of other things too, but it's important for a conveyancer to tell a conveyancing buyer client of the need to have a survey or valuation. Every conveyancer should say that, and the client needs to be aware of the types of survey and valuation and the benefits of obtaining the best form of survey or valuation they can afford, which is a level 3 survey and valuation, which is more detailed than anything else that a surveyor or valuer would generate. The RICS Consumer Guide to Survey and Valuation provides a client with information about types of survey and valuation. So as a conveyancer, I'm going to tell my client that the property should be surveyed or valued, but the client then needs detail about types of survey and valuation. The RICS Consumer Guide provides that. The basic principle in a conveyancing transaction, as I'm sure you're aware, is let the buyer beware, which means the buyer buys the property as it stands. In the state and condition it is at completion. And therefore, if it has structural defects, if it needs a new roof or anything of that nature, the buyer buys it subject to that condition. So it's important that the buyer has independent expert evidence as to the state and condition, and an RICS survey or valuation fulfills that brief. The government does not like leasehold property, and certainly doesn't like leasehold houses. So you've seen what's called a leasehold pledge signed by most of the major developers and house builders, in which they promise the government that they won't sell any more leasehold houses. And any leasehold houses that have been sold can be converted by the entity, organization, company, or individual that has signed up to the pledge, making the acquisition of the freehold to a leasehold property easy, simple, and relatively cheap. So with pre-existing leasehold houses, the government has encouraged the owners of the freehold to sell the freehold to property owners. Leasehold is very much alive and kicking in connection with flats and apartments. The reason why leasehold is so prevalent and so useful in the context of a flat or an apartment is because if a flat was owned freehold, so I own the first floor flat, you're on the ground floor, and our friend has a flat above me where the roof is situated, who's responsible for the repair and maintenance of the roof and the structure to the building? I'm going to turn around and say, well, I'm on the first floor, so it's not my responsibility to repair the roof, and you beneath me are going to say exactly the same thing. But our poor unfortunate friend on the second floor, who is responsible for the roof, is going to be met with bills relating to cleaning the guttering, replacing tiles, perhaps even replacing the roof, which is quite an onerous responsibility. And therefore, in a leasehold context, no one owns the roof or the structure amongst the leaseholders. It is owned by a landlord or a management company that has responsibility for roof repairs, structural repairs, maintenance, cleaning, etc., and transmits the cost of all those issues into service charge. A residential lease in a flat or apartment, therefore, has some logic sitting behind it. Issues such as repair and maintenance, service charge, responsibility for repair of common parts, structure, roof, etc., should remain with someone, ideally the person that built or constructed the development or who acquired it and is the freeholder. So you have leaseholders who own a leasehold interest, ownership for a period of time, and a freeholder who owns the freehold to the land, that has in essence an absolute ownership of the land. And the relationship between the two is subject to a great deal of statutory intervention, acts of parliament that deal with management issues. So a leaseholder in a flat or an apartment has the right to extend their lease, has a right to apply for a right to management, has a right to test service charge on the basis of reasonableness, has a whole raft of different rights of redress against leaseholders, against landlords rather. And the reason for this is that historically it was felt that landlords were wealthy, landlords could afford expensive lawyers, and landlords held the whip hand in connection with the landlord-leaseholder relationship. So from the 1960s onwards, you saw lots of acts of parliament designed to address that balance. So these days, service charge must be reasonable, reasonably incurred, it must be a reasonable expense. There is protection for leaseholders against landlords making unreasonable demands relating to service charge. Leaseholders have the right to extend their lease, have the right to what's called collectively enfranchise, acquire the freehold from the landlord, have the right to challenge administration charges, are protected in connection with remediation costs to an extent in connection with building safety. All of these issues are dealt with within the lease, but there is statute, there's acts of parliament sitting behind the lease, protecting the leaseholder from unscrupulous and nasty landlords. The Leasehold Advisory Service, the Leasehold Knowledge Partnership website, and the Association of Residential Managing Agents contains a vast amount of information which will explain leaseholders' rights, leaseholders' entitlements, and what can be done in situations where landlords are behaving unreasonably. That legislation, as I say, is constantly being reviewed, and the latest review and the latest changes to the law have got conveyancers panicking, namely the Building Safety Act 2022, which in essence requires landlords to check buildings that are more than 11 metres or 5 stories in height, and require landlords to produce certificates concerning remediation work that has been done or is to be done to the property, and also requires a leaseholder to confirm who owned the flat or the apartment as of the 14th of February 2022, in order that the Building Safety Act and the protection it affords could apply to subsequent leaseholders. That's got conveyancers at the moment in a spin. Some conveyancers now won't act in connection with leasehold transactions of flats or apartments on the basis they're worried about being negligent. Some lenders are requiring conveyancers unreasonably to verify information in the landlord's certificate, leaseholder deed certificate that are being produced by third parties. So it's a real mess. But again, it's government attempting to intervene to protect leaseholders in connection with building safety costs, fire safety costs in particular, that are being met by landlords and being transmitted to leaseholders via service charge. So have a look at all of those websites. They're free to access and they're very useful in that they contain a lot of background information that will be useful for you as an estate agent or surveyor or valuer, and of course essential for our friends the conveyancers. The next thing that I want to do is just set out what I'm going to do for the next sort of half hour, 45 minutes or so. I want to talk to you about how we deal with conveyancers, and I want to take you through the conveyancing process, highlighting pinch points during that process. I want to tell you why lawyers are absolutely terrified about property fraud and worried about things like money laundering, seller identity fraud, mortgage fraud, etc. And we'll have a little look at the CQS scheme if we can. As I say, there's no way in an hour I can share with you what limited knowledge I have about the conveyancing process. It would take me a week to explain the intricacies of the process to any material degree. So let's have a look first of all at what the conveyancing protocol does in dividing up the conveyancing process. And also let's just have a look at what we mean by title. Title is simply ownership of land or property. So if I have a car, then my ownership might be a logbook, or it might be the keys to the car. If I have a watch, it might be I've got some form of receipt, etc., that proves I bought the watch. But that's not necessarily proof that I own it. I might have stolen it. It might have been given to me. With regard to land or property, ownership is identifiable courtesy of the title register if the land is registered, or title deeds if the land is unregistered. Title deeds simply documents showing ownership going back historically. Those documents must prove ownership for at least 15 years and must culminate in the current seller being shown to be the current owner of the land. With registered land, there is a land registry, which surprisingly retains a land register, which is a computerized list of title numbers. Every property in England and Wales that is registered is given a unique title number. And then the land registry maintains 3 registers: the property register, the address of the property and details concerning the property; the proprietorship register, details of the owner of the property or owners; and then the charges register, dealing with mortgages, dealing with other interest in land that are recorded on the register. Unregistered land, you're looking at conveyances and legal charges to determine ownership, etc. So title is very important. The seller must establish that they have a good and marketable title, and the buyer must investigate the title to make sure that title is acceptable to the buyer, and where the buyer is proceeding with assistance from a lender, that it is satisfactory for the lender as well. The conveyancing protocol is a framework that the Law Society and other professional bodies agreed many years ago to act as a framework for the conveyancing process. So it creates standardized documents. It imposes standard duties on the solicitors or conveyancers for the seller and buyer. It sets out the mechanics, the process for conveyancing in England and Wales. It is important that you understand the basics of the conveyancing protocol, and what we'll do when doing that exercise is we'll have a look at some of the pinch points that can cause problems and delays in conveyancing for conveyancers and of course for their clients. It's important to understand that conveyancers come in all shapes and forms. You can have a high street solicitor's practice that does a little bit of conveyancing. You can have a solicitor's practice that does nothing but conveyancing. You could have a major city firm with hundreds of offices worldwide, which has a residential conveyancing team. You've got licensed conveyancers and legal executives that might be offering conveyancing services, either as individuals in business or in large organizations and conveyancing factories. It's important that you understand the types of firm that you're dealing with and also the professional bodies that manage or regulate those organizations. So you've got the Law Society regulating solicitors. You've got the SILEX that regulates licensed legal executives, and you've got the Institute of conveyancers, licensed conveyancers, that regulates licensed conveyancers. Whenever you're dealing with a conveyancer or solicitor, it's important to know their professional body. The difference between a profession and any other organisation is that a professional body has additional rules that members must comply with, just as you will have as estate agents or surveyors. When dealing with conveyancers, what you normally find is, in more traditional firms, a solicitor or qualified lawyer that deals with conveyancing files from start to finish, who onboards clients, who deals with all aspects of the conveyancing process, including registration of the title at the land registry after completion. In some firms, you'll have individuals that will have control not of the entire file, but particular aspects of the file as the transaction progresses. So they might deal with onboarding the client. They may deal with steps that are taken up to exchange. There might be someone else that deals with the process from exchange to completion. And then a lot of firms have post-completion departments that don't deal with clients, but just deal with land registration. In firms, you might have a partner or a head of department who has a more senior role, a supervisory role with regard to the firm. You might have a compliance officer that deals with professional obligations and duties. You might have different people within the firm, all of whom have supervisory roles, and you may then have conveyancers that are actually dealing with files day in, day out. You might have an individual doing that, or you might have a team of 4 or 5 conveyancers that each have responsibility for one aspect of a conveyancing transaction. You also have property support lawyers who might necessarily do actually any conveyancing, but will assist conveyancers with regard to problems or issues that they have with regard to conveyancing. The conveyancing process, to be honest with you, is relatively straightforward. It's procedural, and once you've grasped the procedure, it's not that difficult. Because of the use of standard forms, etc., it's not the most taxing of procedures, but an experienced conveyancer can spot when something has gone wrong, or an even better conveyancer will spot something before it goes wrong and will know what to do. So the important thing with regard to conveyancing is to not only understand the process and the procedure, but to understand where things can go wrong and how to remedy them. And the other problem and intangible with regard to conveyancers is that you're dealing with people, and every client is different. Although firms will have case management systems, standard emails, etc., standard processes, every client has to be treated differently. So that you might have a client that's risk averse. You might have a client that's a first-time buyer. You might have an elderly client who's infirm or suffering from some form of capacity issue. You need to know how to deal with all those clients. You need to know what's critical to each client. What's their objective with regard to an acquisition? What's their objective with regard to a sale? What do they want you to do? Do they understand what you're going to do? Do they understand what you're not going to do? A conveyancer will scope his or her retainer. Sounds complex, but all it means is that the solicitor or conveyancer will regulate the relationship between the firm and the client, telling the client what the firm will do and what the firm won't do. The lawyer who's good will also tell the client the limitations with regard to the work that they're going to do. So we can't give advice with regard to valuation. We can't give advice as to the state and condition of the property. We can't advise clients normally whether the transaction is sensible or not. Only if a transaction is exceptionally stupid would a lawyer be required to tell the client you shouldn't be doing this deal. A conveyancer is required to communicate effectively with clients to make sure clients understand process, understand documentation, understand what the conveyancer does, and also understands or appreciates risk with regard to the transaction. Is conveyancing seasonal? It can be. You tend to find, just as you find as estate agents, there are certain times of year that conveyancers are busy and other times where the market quietens. So Easter time, a time for new instructions, a time for everyone who's thinking about looking for houses starting to looking. Better weather, more houses on the market, therefore the market is more active. Then what you find is that you as estate agents get business and get transactions and instructions. When those transactions and instructions are sort of leading to agreement, you'll then produce particulars of sale and instruct lawyers. So lawyers can be anything from 2 weeks to sort of 3 or 4 months behind a boom in the estate agency market. And the same thing will apply in connection with downturn. During the summer, when people are on holiday, the conveyancing market quietens a bit. Back in September through to November, you find it a really busy time. Up to Christmas, a really busy time with people, I don't know why, wanting to be in before Christmas, even though Christmas might be a pretty miserable affair, given the fact they're spending time unpacking boxes and trying to get things sorted rather than enjoying the Christmas festivities. So it's important to understand all of that. It's also important to understand that conveyancers have a huge responsibility with regard to the conveyancing process. Because if a solicitor gets, or a conveyancer gets something wrong, then the person that suffers loss, either their client or someone else, will bring a claim in negligence. And we are seeing an uptake in claims in negligence against conveyancers recently. The reason for that, quite simply, is lockdown, lawyers not seeing clients, lawyers not talking to one another, and therefore issues associated with fraud arising. You're also seeing the vast amount of additional conveyancing transactions being required to be undertaken during lockdown because of the SDLT windows. You also have seen a particularly buoyant market. All of those things create the perfect storm with regard to volume of work, lack of assistance, and therefore risk associated with the conveyancing process, leading to claims. So let's have a look at the conveyancing process, and let's talk about the conveyancing protocol, which was introduced, as I mentioned on the slide, in April 2011. It coincided with the introduction of Standard Conditions of Sale 5th edition, which are the conditions that apply to every contract in every conveyancing transaction which is residential in England and Wales. The only exception to that are auction contracts, where there are special auction conditions or online conditions that could apply depending on the nature of the auction. So you've got a requirement to use the National Conditions of Sale 5th edition, which set out what the parties can and can't do with regard to the conveyancing process, which set out that if completion is to take place, it is to take place at 2 o'clock. That stipulates that the buyer is obliged to insure the target property from exchange of contracts, which explains that where a buyer or seller defaults at completion, the other side is entitled to serve a notice to complete on the other, compelling them to complete within 10 working days. And you've also got a contract stipulating that where a party is unable or unwilling to complete, they are liable to the innocent party for contractual interest. The contract will stipulate the purchase price, will name the parties, will list any problems or defects associated with the title. It will list whether the purchase price includes chattels, items that the seller would be entitled to remove from the property, which the seller is willing to leave, or for which the seller and buyer have agreed a purchase price for. The contract should, at exchange of contracts, specify the payment of a deposit, normally 10%, but the parties can agree a lesser sum. Generally speaking, they can't agree a greater sum because that would constitute a penalty and would be unenforceable. The idea of the deposit is that it is paid by the buyer to the seller's solicitor or conveyancer and is held by them pending completion. Is in essence a sign of good faith that the buyer is committing to purchase the property on exchange of contract. The contract stipulates that the deposit can be paid by the buyer's conveyancer to the seller's conveyancer in one of two ways: as stakeholder, which means the deposit remains in the seller's solicitor's account pending completion, or as agent, which enables the seller to receive the contract deposit monies from their conveyancer after exchange. Clearly, it is safer that the deposit is paid into the seller's client account and remains there pending completion, because if anything goes wrong with the conveyancing process, where the funds are held in a solicitor's client account, those funds are easy to attack and get back in circumstances where the seller has defaulted. So you've got the conveyancing protocol creating a conveyancing process that incorporates standard documents. the standard conditions of sale 5th edition being the obvious one. It also includes the requirement for the buyer to raise enquiries before contract using a form TA, and a form TA6 is the general enquiries before contract, TA7 enquiries for leasehold properties, and TA10 fixtures, fittings and contents form. The idea is that the seller completes these forms and produces to the buyer a contract bundle, which would include the official copies of the register proving ownership in registered land, the TA forms that are due to be completed given the nature of the transaction, a draft contract in duplicate, an EPC, and any other relevant documents. On receipt of the contract bundle, the buyer's conveyancer is expected to consider the title, consider what the seller is saying in the TA forms, and to provide those documents with an explanatory note to the buyer client, so the buyer client can see what the seller has produced. The seller's conveyancer will then perform what's called due diligence, undertaking searches in connection with a new property to find out as much about the property for the benefit of the buyer. There are essential searches and there are searches that may be necessary. Essential searches are a local land charges search of the local land charges department of the local authority, and enquiries of local authority, which will reveal local land charges, whether roads and footpaths are adopted, tree preservation orders, smoke control orders, listed buildings, planning issues. The buyer's conveyancer will also undertake a drainage and water search to ensure that the drains and sewers to the property and the water supply to the property are from a public source. In other words, that they're responsibility of a water company. A drainage and water search is always essential in any conveyancing transaction, as is an environmental search and report. An environmental search and report will reveal whether a property is contaminated. If a property is contaminated, then the Environment Agency can pursue the person that contaminated the land, the owner of the land at the point of contamination, or any subsequent owner or occupant in order to decontaminate the site. Contamination and decontamination can be exceedingly expensive exercises, and therefore it's important to understand and appreciate that an environmental search and report will reveal information about historical land use and risk associated with the land being contaminated and decontamination being required. An environmental search and report might also incorporate a drainage and water search. And just recently, there's been a case concerning Japanese knotweed, where a property was sold by a seller, and the seller failed to disclose the existence of Japanese knotweed in the garden. The buyer brought an action for breach of contract against the seller, was awarded £32,000 for removal of the Japanese knotweed, and was asked to pay £170,000 in legal costs. So it's important to understand, when acting for parties, if there is a dispute or a problem with regard to title, with regard to what the seller is disclosing in the contract pack, with regard to what the seller is saying in the TA forms, it might be open to the buyer to bring an action for breach of contract or for misrepresentation, but that litigation will be expensive, it will be slow, and will be stressful. And therefore, from a conveyancing perspective, it is always best to be protective of your client and to avoid litigation at all costs. The conveyancing process divides the system into 6 stages, as I mentioned on the slide. The obtaining of instructions, normally via an estate agent. The provision of a particulars of sale from the estate agent, showing to the seller's conveyancer and their client, and the buyer's conveyancer and their client, the property that is being sold. The seller then is required to produce to the buyer a draft contract and contract bundle, which would include official copies of the register, a copy of a title plan, a copy of the TA forms that have been completed by the seller, an EPC, and any other relevant information. I mentioned a land registry title plan. The land registry produced plans showing the extent of a registered title. The important thing that you need to be aware of is that a title plan cannot be relied upon. It does not reveal a legal boundary. but in fact reveals a general boundary and therefore is useless for identifying a legal boundary or the exact spot where one title is separated from another registered title. So pre-exchange, a buyer is going to undertake due diligence through their conveyancer. A buyer is going to want a mortgage offer. A buyer is going to want to facilitate the purchase, and the buyer is probably going to need to pay 10% deposit purchase price to the buyer's conveyancer to facilitate an exchange of contract. The buyer should be advised to have a survey or valuation, and that survey or valuation should be provided to the conveyancer for the conveyancer to look at. The buyer client should inspect target property in order to identify state and condition, in order to identify the existence of boundaries, to identify whether there is anyone in occupation or any other form of interest in the property that isn't recorded on the title deeds. These are called overriding interests. If there is someone in occupation of the property who contributed to its purchase price, they have an interest in the property even though their name is not on their title. That occupation, that right of the individual could be binding, could be imposed on a subsequent buyer of the property that is aware of the existence of that interest. That's why inspection is so important. As I've mentioned, the inspection is also necessary to verify that what the seller is saying in the TA forms is correct and accurate. So once we've done all of that and we've provided our buyer client with what's called a report on title, telling the client of what has been revealed courtesy of our due diligence process, assuming our client is happy to proceed, is happy with the mortgage offer and the survey or valuation, then our buyer can think about exchanging contracts. If we're acting for a seller, unless the seller has a dependent purchase, all we need to do is check that there's going to be sufficient money from the proceeds of sale to discharge any mortgages, and we need our client's consent as a seller in order to progress towards an exchange of contract. Exchanging contracts is the creation of a legally binding agreement between seller and buyer. The contracts are normally duplicated documents that are produced by the seller in the contract bundle. The seller will approve the contract and return it to the buyer will approve the contract and return it to the seller's conveyancer for the seller to sign, and the buyer will sign their part contract in readiness for exchange. Assuming the buyer has completed its due diligence process, assuming the buyer is happy with the report on title that has been sent by the buyer's conveyancer to the buyer client, the buyer will be happy to exchange contracts. It is essential that the buyer's conveyancer has a mortgage offer that the buyer has accepted, and it's also important that all searches and other inquiries and any additional inquiries that arise during the process have been dealt with. Once that has taken place and once both parties have authorised their lawyers to exchange contracts, an exchange can take place. On exchange, the deposit is paid over from the buyer to the seller, and the buyer acquires an interest in the property pending completion. Theoretically, the seller cannot sell the property to anyone else. The parties have agreed a date for completion, and they are bound to complete on that date. There's no guarantee that completion will take place, but the parties have contracted to complete as of that point in time. So once contracts are exchanged, then what is necessary is for the buyer and seller to prepare for completion. The buyer's conveyancer will undertake some pre-completion searches, the most important of which is the land registry search. This is a search of the land register relevant to the title from the date of the official copies that were downloaded by the seller and included in the contract bundle to the current date. So what this land registry search does is updates the official copies of the register to see if anything has been added or removed from the register. The land registry search also freezes the title from the date of the search for 30 working days, enabling the buyer to register their ownership after completion and to register any legal charge secured on the property at the land registry without any fear of anyone registering anything else. So this land registry search is so important. It freezes the title and creates what's called a priority period in which the buyer must submit to the land registry an application form, sending the transfer and a mortgage deed to the land registry. Before a mortgage deed or a transfer can be submitted to the land registry, it is important that the buyer's conveyancer pays to the government, or HMRC more accurately, any stamp duty land tax that arises in connection with the property. This is a transaction tax that is paid by the buyer within 14 days of completion, assuming that the property attracts SDLT, and depending on what that SDLT will be. It's normally a percentage of the market value of the property, which the buyer must pay in order for the land registry to accept a transfer of the title to the buyer. So completion is very important from a buyer's perspective and a seller's perspective. The seller provides vacant possession, the buyer pays over the purchase price and moves in. From a conveyancing perspective, however, the job of the buyer and seller's conveyancer is incomplete. The seller's conveyancer is required to pay off any outstanding mortgages that are secured on the title, and the buyer's conveyancer is required to pay SDLT and then submit what's called a transfer document that's been signed by the seller and dated the day of completion, and to transfer to the land registry a mortgage deed, which is a document signed by the buyer and witnessed, which is securing the mortgage advance from the lender on the property that the buyer is purchasing. So at completion, the seller's conveyancer hands over to the buyer's conveyancer the signed transfer, and at completion, the buyer's conveyancer, if the property is being purchased with the assistance of a mortgage, must have a signed mortgage deed. And when I say signed, both the transfer and the mortgage deed must be must be signed by the buyer and seller, that's a transfer, and signed by the buyer, that's the mortgage deed, and the signatures must be witnessed. That's called execution of a document, not the signature to a document. A contract for the sale or purchase of land simply requires a signature. A mortgage deed or a transfer deed, because it is a deed, needs to be executed, which means it must be signed and the signature must be witnessed. Post-completion, we pay a registration fee to the land registry. We lodge documents at the land registry, who then change the title. The seller is removed from the title. The seller's mortgage, if it's paid off, is removed from the title. The buyer is now listed as the registered proprietor, and the buyer's charge is now registered as a first legal charge in the charges register. At that point, the buyer becomes the legal owner of the property. You may think that the buyer becomes the legal owner of the property at completion, when he moves in, when he pays over the purchase price. That isn't correct. The buyer acquires title upon registration, and the seller loses their title upon registration. If there's a delay or if there's a problem, then the protection afforded by the land registry search can be lost, and it would be necessary to do a new search. If there are delays and the search expires, then someone else could theoretically register something against the title in the intervening period. So it's important to understand that conveyancing process and to understand what can go wrong and what can go wrong. What are the pinch points in the process? Well, first of all, the seller being unable to obtain all the information that's necessary for the contract bundle. Title deeds might be lost. There might be an issue with regard to documents that have been submitted to the land registry. The land registry title may be incomplete or imperfect, leading to a delay with regard to the provision of the contract and contract bundle. From a buyer's perspective, there might be an issue with regard to a buyer's mortgage offer. It might not have been received. It might be a problem with regard to getting searches back. Local land charges searches of local authorities can take months to come back. The land registry is taking over responsibility for local land charges, and local land charges searches that are undertaken of the land registry come back same day. But where you're dealing with the district council, the delay can be inordinate. There might be an issue with regard to the buyer getting funds together to pay the deposit or to pay the balance purchase price where they're proceeding with the assistance of a lender. The buyer's solicitor may be unhappy with the title that the seller is offering and might need to take out a defective title insurance policy, which can take time to get issued and take time to get sorted. So there can be all manner of problems during the conveyancing process in connection with procedure. When we're about to exchange contracts, in a lot of transactions, the seller will have a dependent purchase and the buyer might have a dependent sale. So it's necessary not only to synchronize our transaction, but it might be necessary for other transactions in the chain to be synchronized too. Synchronization with regard to exchange and completion. And there could be a need to hold things up while one party to the chain gets their mortgage offer, or their party to the chain gets their searches undertaken. All of these things can take time. Now, I mentioned in my introduction fraud. It is essential that a conveyancer, when they're onboarding a client, before they start doing anything, they verify their client's identity. They can do that electronically. It's also possible to do it the old-fashioned way by asking for copy passports or utility bills or driving licenses. But it is imperative that before anyone does anything, client's identity is verified. Why is that such a problem? A, money laundering, which I'll come on to, and B, seller identity fraud. The land register is an open register. So if I know your name and your address, I can go on the land registry website and download a copy of your title. If I know you, if I'm a tenant of yours, if I can access your social media, I might find out your date of birth, I might find out your pets' names, etc., that might give me a stab or a chance at guessing passwords. And I can then impersonate you and instruct solicitors to act in connection with the sale of your property or its remortgage. Now, you might think, Ian, that's nonsense and ludicrous. It happens quite a lot. It's not a pandemic, as it were, but it happens. And solicitors and buyers lose out as a consequence of the fraudster receiving the proceeds of sale, disappearing off into the sunset, the buyer then attempting to move into the property and finding out that the genuine owner of the property is still there and knows nothing of the transaction. So fraud is an issue, a major issue, and it's important that conveyancers, when they're onboarding a client, are suspicious of the client and do checks to verify identity, and then throughout the life of the transaction they should be aware of fraud and fraud risk. Lawyers are required to undertake a risk assessment with regard to fraud at the start of the transaction. They're also required to assess risk with regard to the transaction itself and the potential for negligence or client complaints. The other issue is money laundering. If I was fortunate enough to have £500,000 in cash and I went to my bank tomorrow to pay it in, the person in the bank would ask me to have a seat and then would ask me to prove where this £500,000 has come from. If I'm unable to prove it, the position is that the bank would contact the police, who would interview me, and until I can prove where that £500,000 comes from, they will confiscate it from me and they will charge me with a criminal offence. If, on the other hand, that £500,000 is paid by my conveyancer as the proceeds of sale of a property into my bank account, my bank won't bat an eyelid. They will think that my lawyer has undertaken checks to verify my legitimacy and the validity of the transaction. So the conveyancing process can wash criminal or dirty money and legitimize it, enabling it then to be taken out of my bank and to be used for whatever purpose I wish. So fraudsters and criminals use the conveyancing process for money laundering. They could buy a property with cash or with illegal funds paid into a solicitor's client account, and then the moment it's paid out and used to facilitate a purchase, then the fraudster, the criminal, acquires title. They can then sell the property and get the cash back legitimately. Other examples of money laundering activity and criminal activity, pretending to buy a property. So I instruct you to put an offer in on a property that you're selling in central London for £10 million. And then what I do is I go and see some lawyers and say, look, I've just put an offer in to buy a flat in central London for £10 million. The estate agent is telling me we need to move quickly, so I'm going to pay £1 million into your client account in readiness for exchange. What then happens is 3 or 4 weeks later, the client tells the lawyer, oh, I'm not buying that property anymore. Will you pay that £1 million back to me so I can use it in connection with another transaction? As and when I'm buying the property, I'll instruct you to act for me again. Again, that £1 million comes out of the lawyer's client account and it's being washed, in that the lawyer can say legitimately, the client can say illegitimately, that was the proceeds of sale of a house in Manchester, or a flat in Manchester, and my lawyers completed the sale of that flat and paid that £1 million to me into my business account or savings account. So there's lots of opportunity for fraudulent activity. The English legal system has two types of land ownership, freehold and leasehold. Freehold is absolute ownership subject to the rights of the Crown. Freehold is ownership of the land for a period of time. With a freehold, there is simply evidence of title or ownership. With leasehold, there's evidence of title relating to the leasehold title, but there's also the necessity of having a look at a lease, which contains rights, duties and obligations between leaseholder and landlord. So covenants relating to user, for example, you can't keep domestic pets, you can't carry out trade or business activity from the property, you can't use it for Airbnb letting. The lease will contain these sorts of provisions. Also provision for repair and maintenance. Normally the leaseholder is responsible for the repair of the flat or the apartment. The landlord is responsible for repair of the building and insurance of the building, with leaseholders being required to contribute towards costs. A residential lease will normally have a forfeiture clause which says the landlord is entitled to repossess the property in circumstances where a tenant has breached their obligations or covenants within the lease. I mentioned the English legal system is divided between registered or unregistered land. There are approximately 1.4 million properties in England and Wales that are unregistered. The vast majority of land in England and Wales is registered. It's easier to prove ownership and it's easier to deal with as far as conveyancing is concerned. But registered land and the opening up of the public register means that registered land is susceptible to intervention by fraudsters. Registered land is provided with a state guarantee, which is transmitted to the land registry, then transmitted to practitioners and clients who own registered land. The state guarantees your registered title. With unregistered land, there is not the same state guarantee. With unregistered land, there is an obligation to register the land where the land is sold or where the land is mortgaged, as I mentioned earlier. We've discussed the steps that are taken by conveyancers before exchange. We now know what happens at exchange. We know that the buyer must undertake pre-completion searches and must draft a transfer and make sure that the client has got a survey and valuation and a mortgage, and the mortgage deed must be signed before completion. So we've understood all of that, hopefully. So pre-exchange, there's lots of work for everyone to do, which we've covered and is shown on file. Then we've got exchange of contracts, preparing for completion, payment of SDLT by the buyer, discharging of mortgages by the seller, registration of title by the buyer at the land registry, and then closing the file. As far as the conveyancing process is concerned, there are a number of things to be aware of. One, clients might have a reason to delay a transaction or might be unhappy about what's being proposed relating to the transaction. That can cause delays. Where you're acting for more than one party, a buyer and a lender, or a series of buyers, it's necessary to get everyone singing from the same hymn sheet. That can cause problems. Defects in title and the need to take out defective title insurance can cause delays. And the synchronization of one transaction with another, sounds easy, but often can be very complicated. There might be 14 or 15 different firms and clients all involved in a chain of transactions that all need to be synchronized. And it can take days, if not in weeks, to achieve that synchronization. That can cause delays. Hopefully today has been of some interest to you. Hopefully I've shed some light on why conveyancing causes so many problems. There are problems with regard to delays. There are problems with regard to ineffective communication between lawyers and their clients and everyone in estate agents. The land registration system theoretically simplifies the process but also complicates it. There are vast amounts of land in England and Wales that's unregistered that causes problems with regard to delays in registration. There is severe risk with regard to property fraud and mortgage fraud, which is why lawyers are very circumspect with regard to taking on new clients. And lenders will sue solicitors and conveyancers if solicitors or conveyancers don't comply with lenders' instructions. A lender is an entirely independent client of the buyer client, and in residential transactions where the lender is an institutional lender, a conveyancer can act for both buyer and lender, but that of itself can create problems. I'm going to finish at that. If you have any questions or queries with regard to anything, drop me a note at the email address shown and I'll happily answer it. But what I'd like to do on behalf of myself at IQ Legal Training, on behalf of today's conveyancer who has organised this event and National Conveyancing Week who have invited me along, I'd like to thank you for listening. If you have any questions or queries, do feel free to send me an email, but it's been a pleasure to deliver this webinar to you all. It is pre-recorded. I hope you enjoy listening and watching it, and I'd like to thank you very much for coming along today. Thanks everyone, stay safe and goodbye.